Good afternoon, everyone, and welcome to the Children's Law Centre's first lunchtime webinar. And hopefully this will be the first of many seminars that we're going to run over lunchtime, sort of a bag and chat type event. And we hope to develop this series. And so if you have any ideas of issues that you'd like us to address, please let us know. You'll all have received an email to say that we are recording this event. If you don't want to be recorded, please turn off your camera. If you would like to put questions in the chat, my colleague Fergal is going to monitor those and send those through at the end. So you're all very welcome. And I'd like to give a particularly big welcome and thanks to Bruce Adamson. Bruce's CV is in the chat, along with a link to the UNCRC Incorporation Scotland Act 2024, a link to a chapter that Bruce has edited, along with some background information re-incorporation into Scottish legislation of the UNCRC. So that's all there for you. Suffice to say, I've had the pleasure of working with Bruce to vindicate children's rights in these jurisdictions since 2017, when he became Children and Young People's Commissioner in Scotland. He has been, and I don't say this lightly, but he has been an amazing advocate and champion of children's rights, and I've learned an awful lot from him. And what he and colleagues have achieved in Scotland has been inspirational, and I am very jealous for our children here. So, Bruce, thank you very much for being with us today and for giving so freely and generously of your time. And can I congratulate you, Bruce, on being elected as Vice Chair of Eurochild last week? I think the organisation is very lucky to have you. So just by way of introduction, I wanted to reflect on why we're talking about incorporation now. I suppose we have been inspired by what's happened in Scotland, and it's reignited a discussion that we had some time ago in this jurisdiction. We had hoped that the UNCRC would be incorporated into our domestic legislation via the Bill of Rights, which was provided for in the Good Friday Agreement. But that has been slower than we'd hoped. But there is a growing conversation in this jurisdiction around incorporation of international human rights instruments more generally. And I'd like to recognise the work of the Human Rights Consortium in relation to this, but also Disability Action and what they've done around the issue of incorporation of the UNCRPD. The recent UNCRC reporting that both Bruce and I were involved in, and the recommendations identified huge children's rights deficits across the 4 jurisdictions in the UK. And they also identified legal gaps as well in terms of the legislation. For us, things like the minimum age criminal responsibility, the fact that children don't enjoy equal protection from assault, and the absence of age DFS protections. The other issue why it's important at the minute is like other organisations, the Children's Law Centre is experiencing growing challenges in vindicating children's rights, including through litigation. So we think it's really timely to have this conversation and to learn from Scotland and see what we can do to better protect children's rights in this jurisdiction. So against all that backdrop, Bruce and I are going to chat for about 25 to 30 minutes, and then we'll open it up for questions. We do have quite a few people online, so apologies if we don't get to your question. So Bruce, after all that, you and I chatted last week, and I think we agreed we want to mainly focus on the legislation and the process of incorporation, because I think that's something that we haven't delved too much into in this jurisdiction. But I wanted to have a few short questions. Just in a couple of sentences, Bruce, why do you think incorporation would ensure better realisation of children's rights in Scotland?
Paddy, thank you so much for such a wonderful, warm welcome, and thanks all for joining us. And I want to start really just by thanking you, Paddy, for your incredible leadership of the Children's Law Centre over there, but also your incredible international contribution, particularly over the last 27 years at the Children's Law Centre. I know that you're into your final few weeks, and you're going to be hugely missed. You've been such a huge inspiration to me and others, and such a strong source of expertise and drive for change. You continue to leave such an incredible legacy. I know that you don't want to talk about things in terms of legacy, but the impact of your work will be felt for generations. And certainly, I wouldn't want to start without thanking you first. And thanks everyone for joining us. I know that the sun is probably shining where you are at the moment, and so it's very difficult to be inside on a day like today. But I believe that incorporation of the UNCRC is a really bright ray of sunshine in what is an increasingly dark world. For me, it's about accountability. The obligations under the Convention on the Rights of the Child have existed for over 35 years. These are things that are already commitments by our governments, but children speak consistently about the lack of access to justice and accountability. And the Committee on the Rights of the Child made really clear that without effective remedy, these rights can pass into meaninglessness. And so in a time where there's a lot of competing priorities on duty bearers, where budgets can sometimes be tight and other domestic obligations might be seen as more important, what incorporation did here in Scotland was provided that domestic legal basis, which really focuses hearts and minds, but also budgets on ensuring that children's rights are at the heart of decision making. And so that was what this was about, was accountability and bringing rights home and really focusing the rights contained within the Convention on the Rights of the Child at the heart of decision making, including children's voices and their best interests.
Thanks, Bruce. I'm conscious that every journey starts with the first step. So what was the first step in the campaign to deliver incorporation?
Yeah. I mean, we stand on the shoulders of giants here, and that incorporation was something that was talked about even by those that were drafting the convention in the first place. And we've got incredible civil society in Scotland who had been part of the campaign for the Convention on the Rights of the Child, and then very quickly, following the ratification of the convention, we're already talking about incorporation and building some of the legal structures here in Scotland. And so one of the things that was really important in the early days of devolution and in the late 1990s, early 2000s, was the creation of a children's commissioner. And so the Children's Commissioner in Scotland was created by an Act of Parliament in 2003, and that was very much aligned to the need for accountability and incorporation. And the first Children's Commissioner, Professor Kathleen Marshall, made this one of her priorities, alongside really strong civil society partnerships. And so the fact that this has kind of been embedded into the way in which Scotland has worked and thought about itself since devolution. So that's really key, that this has been a really long-standing process, but really gathered momentum around what became an Act of Parliament in 2014, following some of the work that had happened in Wales, where there was a push towards some form of incorporation, kind of a due regard principle, where those in power needed to think about children, and how disappointing the government's response was to that. So a lot of work had been done. The creation of the Children's Rights Alliance in Scotland, which is called Together, and a lot of their campaigning leading up to this 2014 Act, which was a huge disappointment. And I think that really, for me, was a spark that got children and young people through the Children's Parliament and Youth Parliament and civil society really focused on a proper campaign that was focused on legislative change.
Thanks, Bruce. I think a lot of people online would be, aware of the work of Together and key children's rights organisations in Scotland. Be really interested in how you built support among those who would not have been obvious allies. Because I think from my understanding, I was quite critical in getting you over the line.
Absolutely. One of the things that I'm most proud about with the incorporation process here was the really broad support that we were able to build from that really disappointing period around the 2014 Act, where the government was saying, well, actually, it's not even possible to incorporate, or it's not desirable to incorporate. Us having to kind of go back to the drawing board a wee bit and really galvanize that civil society support, and also think about who was missing. And so some of the key allies were parenting organizations, because again, this misconception that children's rights might in some way conflict with parents' rights, which we know is totally wrong. Parents are the greatest champions of children's rights. They're amazing human rights defenders for their children and alongside children. So getting parenting groups be front and center of this was really important, and particularly those parents groups who had children whose rights were most at risk, and so disabled children, those in the care system, the justice system, those experiencing poverty. So linking some of those issues that were really important in everyday lives to the rights framework in this campaign was really important. So parenting groups were really key. We had some really important discussions with faith groups as well. And again, the Church of Scotland at their General Assembly passed a resolution or a motion in relation to incorporation. So speaking to some of the faith-based groups was really important across the board. And some of those conversations were quite challenging at the start, but really trying to help people understand that incorporation aligns with their values and achieving their aims was really important. The professional groups and the trade unions, those particularly who deliver services to children, they're a really important ally as well to, again, make sure that we're clear here that what we're talking about is structural accountability, systemic accountability, that this isn't about the obligation of an individual social worker or teacher. This isn't another stick to beat hardworking professionals with. Sorry to use a violent analogy, but this isn't about attacking those that are working hard to deliver services. Rather, this is a mechanism whereby they can use their skills and experience to speak to budget holders and decision makers to try and improve services. And then the other important ally that was a bit of a surprise were some of those political parties and members of political parties who historically maybe seem to be quite hostile to human rights. Getting them on board was really important, and one of the great successes where we were able to engage with them in a language that helped us communicate better that this was an important tool about service improvement, which would deliver better results for their constituents. And so a lot of our discussion with some of the more conservative members of our parliament were around the value of incorporation as part of service improvement and access to justice, which is something they hold very, very dear. And the conservative members of our parliament actually became some of the biggest champions at the late stages of our legislative process, because they saw this as an important democratic access to justice process that helped deliver more efficient and better services and better outcomes, which is something that everyone in the parliament cared about.
I think we could probably spend a whole seminar just talking about that alone. Can I, just before I turn to the legislative process, Bruce, and I know you're a real champion about the voice of the child, and I've seen that in action in Geneva. I just want to ask, how did you ensure the voices of children and young people were at the core of this process?
Yeah, I mean, children and young people absolutely led this process, which was amazing. And again, huge credit to civil society organizations, primarily together, who really galvanized a lot of the support. And some of it came out of that process I talked about back leading up to the 2014 Act, where children and young people had actually actively put in submissions. So our Children's Parliament and our Youth Parliament and the civil society submissions were really based on the voice of children, really calling, demanding political decision makers to recognize their rights through incorporation, and that huge disappointment. So our Youth Parliament played a really important role. They made this one of their thematic priorities and did a big piece of work in surveying 70,000 children across Scotland. As Children's Commissioner, my young advisors were very front and central in relation to engaging with this, and the broader together membership were really powerful in making sure that it was children and young people who were directly communicating with decision makers.
Can I turn to the legislative process, Bruce? And I was wondering if you could share with us how the drafting process happened and how it developed and changed as things progressed, and maybe a wee bit about at what stage you began looking at the drafting. I mean, because I think part of it here is that, let's get everything, all the support and the political support, etc., and then we'll look at drafting. So I'm interested in how you how it happened in Scotland.
Yeah, absolutely. This is something that I was really passionate about, because incorporation is a legal process, and what we're after is a piece of law. And so, to my mind, that meant that we needed to start with the legislation. And so, as soon as we got to the stage in 2017 where we were starting to galvanize kind of political and civil society support for this process, we wanted to move very quickly to discussing a draft. And the Scottish Government had agreed to consider incorporation in their legislative programme in 2017. And then in 2018, they actually agreed to go forward with incorporation, which was a little bit of a surprise to us because we hadn't quite thought we were there yet with the commitment, but was a really pleasant surprise. But what became apparent very quickly after that is that the government hadn't put in place a drafting team. They hadn't put in place the resources necessary to take this forward, and that what they were proposing was a very kind of long consultative process and lots of talk. And that really upset me because we'd had, as I said earlier, decades of work on this. We knew what children and young people thought because they'd been giving their views very strongly for decades. Some of those children were adults now, working on the campaign as adults. So the idea that we needed a kind of a long consultative process as to incorporation, I felt was wrong. And so what we did is we very quickly set up an expert advisory group, including fantastic contributions from Laura Lundy from over there in Northern Ireland, and Esther Cook-Kelly from University College colleagues from Wales, and I think we've got Welsh colleagues on the call today as well. And we brought together experts on children's rights, experts in incorporation. We also really focused on getting constitutional lawyers and other Scottish lawyers who would help understand the drafting process. And we just drafted our own bill. And so what we did is we sat down and we drafted a bill based on all the consultation and views that had already happened. And so within just a matter of weeks, between kind of October and Children's Day on 20th November, we drafted a bill. We engaged our young advisors in that. Together was a co-founder of that group. And we drafted an incorporation bill which met the aims that we had, which was full and direct incorporation of the Convention on the Rights of the Child, alongside some measures of implementation as well. And we paraded down the Royal Mile on World Children's Day with the Children's Parliament, so some very, very young children, as well as members of the Youth Parliament. Kika Otane, who was a member of the Committee on the Rights of the Child, had come across for a sitting of the Children's Parliament. And if you know Edinburgh at all, at the top of the Royal Mile is the castle, and at the bottom is the Parliament. And we marched down the Royal Mile in great procession with children and banners, shouting their demands for incorporation. And then we presented to the government our incorporation bill and said, this is the starting point. Let's discuss. You don't have to pass this bill as it is, but let's discuss this. The starting point has to be the law itself. This is a drafting exercise. The consultation has been had about why we need incorporation and what type of incorporation. Now this is purely a drafting legislative exercise. Let's go from here.
I think that's absolutely inspirational. Can I just take a stage further? What happened next, Bruce? And did they accept the bill in total? Did they, seek to amend it? And who actually introduced it? Was it the government themselves? Was it a private member's bill? And how pivotal was that?
Yeah, I mean, it was days of tiny triumph and weeks spent in despair. I'm afraid it was disappointing. So government said, thank you very much, but we're still going to stick with our plan of consultation. So then it became a real fight. And actually, this was a point of tension, I think, particularly between me and government. Government saying, look, you should be really congratulating and celebrating this because we've made a commitment and we'll do it eventually. And me constantly saying, this is prevarication, delay. Every day that you don't pass this piece of legislation is another day that children are denied the protections that you've promised them. Let's get on with it. And so the next few years was quite challenging, and government, probably understandably, was very frustrated with the approach that I was taking of saying this is a matter of urgency, whereas they would have preferred a slower process. Where we ended up was a a lot of delay. And then the next summer, there was a consultation, which included our draft bill, but alongside every other option, including not really incorporating. And that dragged on for a bit before we were able to get it back before Parliament with a draft bill from the Scottish Government, which looked pretty similar to the bill that we had drafted, but it perhaps served the purpose that they needed to feel that they had that level of control. But every step of the way, we were really pushing them, saying this is a matter of urgency. It has to be full and direct incorporation. It has to contain those measures of implementation as well. And every day of delay is another day of failure here. So government, I think, would have preferred a more kind of celebratory process. But for me, it was about really constantly pushing. So then when government did introduce the bill, it looked fairly similar to the one that we drafted, but there was a process of really testing that, which we went through, which took some time.
Leaving aside the implications of the Supreme Court ruling, which we'll come back to later, were there any compromises that either the government forced you to make? In other words, that they, to get it over the line, you had to say, okay, I'm not going to dig my heels in this. Or was there anything you had to compromise with colleagues in terms of even your own draft of it? And sorry, I'm rolling a few questions into one here, but was there anything you'd like to have seen in the Act that was actually passed that you had to forgo to ensure that you got it through?
Yeah, I'm really pleased with the Act, and actually some of the things that we got through, I was a bit surprised about. Some of the points of discussion were around things like scope, in terms of particularly the way in which applying to all public authorities, but how far can you apply this to private actors, the kind of private sector fulfilling public functions? And we've actually managed to stretch our definition broader than the Human Rights Act, which was really important because, as some of you will know, there has been a real restriction on scope of the Human Rights Act. And so we wanted to really avoid that and open this up to say anyone who fits within the kind of broad duty bearer definition, anyone who's delivering a type of public function, no matter who they are, really should be caught by this. So we managed to get a very broad definition of the scope of the bill, which I think was really hard fought and won because there was quite a lot of tension around those discussions. There was quite a lot of discussion around the UNCRC itself, recognizing that this was a treaty that's 35 years old, a treaty that was drafted by compromise. And so many people argued that actually what we should be doing, and I know this is a very live discussion there, would be drafting a new Scottish Children's Bill of Rights, that actually we could do better than the CRC, and that we could draft in new rights and Scottish specific rights, and actually a new Scottish approach might be the way forward. And so we were really clear that there were the reasons we didn't want to do that is the need to stay linked to the international framework, that the CRC as a living document and the work of the Committee on the Rights of the Child through things like its general comments, its concluding observations and decisions under the Third Optional Protocol, are ways in which the Convention has been interpreted to understand a changing world with kind of digital change and the impact of climate. So that was quite a discussion as well, and I think the concern I had with going in a different way and coming up with our own approach was that we would lose the connection to the international community and the living document. We would lose the connection to some of the comparatives law that we would be able to keep with the Convention, and also the risk that drafting something by committee would take a really long time. So that pure approach of taking the CRC into our law was something that we had to discuss a lot around, and I was very much on the side of saying, no, let's have full and direct incorporation of the CRC. It's a really kind of good way forward, but that was a bit of discussion. Another point of discussion was where I'm happy to admit I started from the wrong place, where in terms of whether you have an incorporation act, which is purely based on accountability of the CRC, or whether you build in other measures of implementation, some of the tools that can be used, budgeting, impact assessment, participation tools, and you write them into the legislation. My starting point wasn't to include some of those. It was to have a more kind of pure accountability Incorporation Act, but civil society fought really strongly, and they were right, that actually including those measures of implementation into the same piece of legislation really strengthens it, and the way in which they support each other is really important. But that was quite a big discussion as well. Where we ran into trouble with the Supreme Court, again, was a surprise, in that we tried to extend the scope of the legislation to include acts of the UK Parliament on devolved matters, or when the Scottish Parliament had amended UK legislation, and the Supreme Court decided that those things weren't within the legislative competence of the Scottish Parliament. And so that was something that was a point of discussion. But interestingly, throughout the drafting process, we'd probably taken a more conservative approach. And it was quite late in the process that the Scottish government initiated this idea that we would extend the scope a bit further. And it turns out that we extended it further than the Supreme Court determined legislative competence to be. But that wasn't as much of a kind of a sticking point as you might have expected. That was a bit of a late stage discussion. Through most of the drafting of the bill, we'd actually taken a more conservative approach to that.
I'll come back actually to that point around the Supreme Court, if I may, but just can I go back to the measures of implementation, and it may be too early to assess it, but what do you think how beneficial has that been in securing compliance by duty bearers, in the sense, like, if they're looking at legislation, are they children's rights proofing it now in a way that they mightn't have before? If they are drafting it, are they considering about the implications for children and young people of budgets or policy decisions? What has it changed their thinking and how they discharge their duties? I suppose sort of changing upstream as opposed to having to litigate on the basis of the Act. So yeah. I say it may be too early, but have you any sense of that?
Yeah, I think this is fascinating, because the international evidence, which we based a lot of our arguments on, shows that that's absolutely the case, is that having the accountability mechanism actually changes culture. And so a lot of our arguments throughout were, this isn't going to lead to a massive tidal wave of litigation, because litigation is the worst way to resolve anything. Actually, what this does, the fact that you have a legal accountability actually changes the way in which you do those things at the start. So doing proper impact assessments and rights-based budgeting, children's participation, because if you do those things right, then you mitigate any risk in relation to potential litigation. And that's what we want to change. But without that accountability, the motivation to do some of those things is much weaker, even though we know that they work. But with competing pressures, it can be a real challenge. So making it a legal obligation focuses hearts and minds. And so I think what was really interesting about the Scottish experience was that it was, even though we'd had some success with building participation models and impact assessments, that really accelerated massively once it became clear that there was political support to incorporate. So it wasn't from July last year when the Act came into force. It was actually right back in 2018, 2019, when decision makers realized, public authorities, public bodies realized that actually this was going to be a thing. So suddenly we had people like the police and colleagues from across local authorities in Scotland actually really wanting to engage in these discussions around getting their staff trained up, particularly things like impact assessments, rights-based budgeting. How do you do participation? Those things. Suddenly there was a huge upsurge in interest in those things, and we saw that real culture change from quite early in the process. We didn't have to wait until the Act was through, but as soon as it became clear that the Act was going to become a reality, that really got people moving towards action. Unfortunately, we then had COVID, and the pandemic had a devastating effect on children's rights. And so that became a real challenge as focus shifted to protecting life and health. And unfortunately, we didn't take a rights-based approach to that in Scotland, as well as, I'm very much on record supporting the way in which the government dealt with the pandemic here. But it was a real struggle to keep that focus on a rights-based approach. And so children played a really important role in helping with that. And then when we got the legislation through, unfortunately, the Supreme Court challenge really showed, I think, how closely tied the change we were making in culture to the legal enforceability. Because when the Supreme Court challenge happened, and then it became less clear that this legislation would come into force, suddenly the engagement with a children's rights-based approach really dropped away. Suddenly all of that positive energy started to dissipate very, very quickly in terms of those that were engaged in some of those discussions and training and support. When the question mark arose that whether we would be able to get this legislation back, suddenly that culture change stalled. And I think, to me, that's actually one of the greatest pieces of evidence to show just how important the legislative process is, because that was obviously what was driving change.
Wow, that's really interesting. I hadn't heard that before, that sort of shift from, that positive culture, and then the fact that it mightn't become law, that fell away. And then once it became that you were going to be able to save the act, as it were, I think there's a lot we can learn for that in terms of, for example, the lack of enforceability in relation to our equality duty is a major stumbling block. So there's a lot more to be mined in terms of that conversation, I think. Just sticking with the Supreme Court, and can you very briefly, because I'm conscious of time here, explain what the case was, what the outcome, and I know you've alluded to it, was, and how has it, or how can it be mitigated? And what I would say, we are in a slightly different jurisdictional position here, in that because of Stormont operating for quite a substantial time in this jurisdiction, we'd only had direct rules, so most of our legislation would be coming through either Stormont or laterally the Assembly, so maybe we have a bit of a cushion there, but I still think we need to learn in relation to the experience of that, and what we could head off, if anything.
Yeah, it's almost painful to talk about, Paddy, because there's been a lot of reflection on this. So the reference to the Supreme Court by the UK government, the UK law officers, was that what the Scottish Parliament had unanimously agreed to was a piece of law which would apply to all devolved matters. But the law that was created in relation to devolved matters, some of it came from the UK Parliament, and so we had acts of the UK Parliament on substantial matters of Scots devolved law, like education and social work, that had been created by the UK Parliament, and then transferred through the devolution, the Scotland Act, to the responsibility of the Scottish Government and Scottish Parliament. And what we tried to do with our legislation was to include all of that, and said everything within the powers of the Scottish Parliament and the Scotland Act should be covered by this legislation. The Supreme Court said that was outside of the power of the Scottish Parliament to do, because it's related to acts of the UK Parliament. So even though it was only, we'd written it in a way to make it clear that it only applied to devolved matters, the source of that devolved law, which it effectively became the issue at point in the Supreme Court. And there was another piece of legislation which related to the European Charter of Local Self-Government, which was in the same position. So both of these were heard at the same time, and the UK government was successful in its arguments that the Scottish Parliament couldn't pass legislation which had an impact on matters of law passed by the UK Parliament, even on devolved matters. And so it really restricted the scope there. And partly this was a problem because so much, and Paddy's made this distinction already, but in Scotland, so much of our legislation had been done just by amending pieces of UK legislation on devolved matters, rather than passing new Scottish law, or where we'd had quite recent law that Scotland had passed through the UK Parliament pre-devolution. And so a lot of our legal legislative framework had its origins in UK law, and so those things were now suddenly outside scope of the Act and of that bill. And so again, I think two things, and I'm aware of time, Paddy. We tried to intervene in the case and were rejected by the Supreme Court, who said this isn't a matter of children's rights, this is purely a constitutional matter. And in their judgment, they made that very clear as well, saying that nothing in this judgment is in any way to suggest that the Scottish Parliament can't incorporate the Convention on the Rights of the Child. And in fact, I would argue there's an obligation to do so, but that the limits of the devolution settlement are such that you can't apply it to acts of the UK Parliament, even on devolved matters. The second point that I would make is that as soon as the judgment was out, we met with the Scottish Government and said, okay, there's a really, really easy fix here. We just carve those bits out and we deal with that in the future by the Scottish Parliament repatriating those things by passing Scottish law. But Scottish Government wanted to take its time to consult. And so then we had another extended period of what I classified as prevarication and delay to come up with a fix that was fairly much the one that we accepted, that we suggested on day one.
Brilliant. As I thought would happen, Bruce, we talk longer than I had allowed for, and I am conscious that I want to bring in some questions. But so I'm going to edit out a couple of my questions, but one, I think, final, very important question for me is, what do the young people who are involved think of the process and the end result?
Yeah, I mean, this was, as always, the best part of it. The young people are hugely proud, and I think that some of the children who've been involved in the earliest parts of the process were now adults as part of it. So this has been a generation of children and young people in Scotland who are hugely proud of this. And some of the organisations like the Youth Parliament and the Children's Parliament, who are really central to this, Together's membership, really central to this, and really then wanting to then take ownership of it. And it's like, this is part of a process, but now we want to use it. Because they were the ones that were expressing huge frustration about the delays. And also it's important to recognise the different experience of time. Well, a couple of years for a legislative process isn't the end of the world for someone my age. If you're a child, 2 years is a vast amount of time, and 2 decades is more than your whole childhood. And so children were hugely pleased that we got that through. And I'm aware of time, but I always like to quote the young people that I'd worked with, and they had these 7-word stories that were really important. And they came up with things like right to help before you even ask, these kind of positive obligations on the state, and my rights are my armor to me, those protective elements. My rights give me power, freedom, courage. These ideas that children understand their rights, and now in Scotland have a legislative protection of those rights, is something that they've really celebrated. And now it's allowed the conversation to move on to saying, what does this mean in practice, and how can we be part of that leadership of the cultural change?
Yeah, I think, those are inspirational words from the young people. I think that sums up why it's so important. And I think you've answered my first question here, which was about, does the Scottish UNCRC Act enable young people to hold decision makers and public bodies to account directly? And I think that you've said that it actually does.
Yeah, again, we've got a long way to go in terms of really maturing some of those mechanisms, but the fact that we've now got a starting point of a requirement on public bodies to take a participative approach and to explain that participative approach, impact assessments, rights-based budgeting, and then that really powerful accountability tool where there is failure. That hasn't been kind of fully tested yet. It hasn't been fully developed yet. This will be an ongoing kind of living process. But the fact we've got a framework for it is something to really celebrate.
Yeah, I think there's been one case. Am I right? To date?
Yeah. So there's been a case in relation to the scope of the Act and whether it applies to criminal decisions to prosecute, and the courts decided that it does.
Brilliant. I have a question here from Rachel, who's from Nicky, our Children's Commissioner. How does Scotland's form of incorporation compare to other countries that have incorporated the UNCRC?
Brilliant, thanks. Anne Skelton, Professor Anne Skelton, who was the former chair of the Committee on the Rights of the Child, says that this is one of the best pieces of legislation that she's seen anywhere in the world. So I've got that written almost everything that I talk about at the moment. So ours is really strong. Where I think it's particularly strong is that it's secured that full and direct incorporation. Then it also has interpretation clauses, so that says that the courts can then use things like general comments and concluding observations, but also really interestingly, the decisions under the third optional protocol, these communications to the Committee on the Rights of the Child, which the UK hasn't ratified, but our courts can actually consider those decisions in interpreting the convention, and broader interpretive elements in terms of things like days of general discussion and others. So suddenly we've got this kind of rich jurisprudence and kind of secondary law that our courts have a statutory obligation to think about, or they can include. So that's really, really exciting and goes further, I think, than in lots of other places. Some of the implementation measures, I think, go further than in other places. And we also have strike down powers and declaratory powers where our courts can use this to ensure that legislation complies with UNCRC and our Parliament under those obligations. So I think it's a really, really strong example of good legislation. It's not perfect, but and I would hope that the Northern Irish one might even go further. But it is really strong and stands up to international comparison.
No, I think it's a very strong piece of legislation. It's given us a very strong blueprint, and I think if we got it here, we'd be delighted. But certainly, we'll pitch for higher still. There's a question here. It's from Deirdre McAliskey from STEP NI, and I'm going to read this one out. As the UK government approach to immigration continues to drift further from international law on the rights of asylum seekers and refugees, how might the incorporation of the Act provide protections or remedy for children seeking international protections in Scotland?
Yeah, that's a really important question, and I know like all of you, I'm really feeling those dark clouds at the moment, that the international pressures and the international direction of travel, and then domestically seeing some of these really concerning attacks on core human rights values is hard to take. What incorporation does, even though this only applies to devolved matters, and so there isn't direct incorporation in relation to reserved issues like immigration and asylum, we can argue very strongly about the obligations on local authorities to ensure the rights of children who are within the UK at the moment, or within Scotland at the moment. So that's really important. And in fact, even before incorporation, some of the strategic litigation that I did was on this issue, ensuring that local authorities in Scotland understood that their obligations to children who are living here, irregardless of their immigration status, still exist in terms of doing proper needs assessments and delivering services, even when there's no recourse to public funds orders and things like that. And so this was already something we were really active on. And it provides a really strong framework for ensuring that children who are in Scotland are protected. Unfortunately, because of the way in which the devolution settlement works, it doesn't directly apply to immigration decisions themselves. But obviously, we've still got human rights protections and others which are being challenged. So what I hope that it does is provide some strong legal protections for ensuring children's rights while they're here, and also really sets an example for the approach that we should be taking more broadly. Our discussions with the UK government have been really challenging in terms of pushing for incorporation of obligations there. And I'm not hopeful, unfortunately, about that. But I hope that at least provides some kind of ray of light in amongst all of this darkness.
Can I take that question and link it back to something that you referenced earlier? Children's Law Centre and STEP, indeed, along with others, have been advocating along those what we're calling domestic issues, domestic human rights issues like education, housing, health for refugee and asylum-seeking children, and it's been challenging. And one of the issues is where you have third-party, in other words, non-state, non-government, like those who provide housing, etc., who are not immediately. Obviously, it's not immediately obvious that you can actually judicially review them. Am I right in thinking that the scope of the legislation in Scotland will allow that protection against those providers of, for example, housing like MERS?
Yes, and so this was one of the things that, again, one of those points of discussion around the issue of standing. And while we'd actually had an opening up of that a little bit in Scotland over recent years, we were really clear within the Incorporation Act that we wanted to open that up to ensure that those working with and for children and young people were able to take action. And also the Children's Commissioner and the Human Rights Commission have specific statutory powers to take cases in their own name on behalf of children, as well as third-party interventions.
That's interesting. I have a question here from Peter Bryson in Save the Children. He wants to extend his thanks to you and asked if you could speak a bit more on the measures of implementation and how do you measure the impact of incorporation over time, and how has success been defined in Scotland or elsewhere?
Oh, that's a huge question. I'm looking at the clock, but it is a really important one. So the measures of implementation are kind of set out in list format within the Act, which is hugely important. But they include things like a requirement to have children's participation in decision making and to access the support and representation that children get as well. So a requirement to focus on things like legal aid. So not only do you have to ensure participation, you have to ensure that forms of access to justice that need participation support are funded as well. So there's actually a requirement to look at third sector funding. There's a requirement to identify and access issues of protection. There's a requirement to raise awareness, which specifically includes inclusive communication. There's a requirement to promote complaints handling. There's a requirement to look at access to justice, requirement to consider rights-based budgeting, and requirement in relation to impact assessment. And all of that's supported by a requirement for regular reporting as well. There was some discussion around who all these reporting duties and things apply to, and so most of them apply directly to government, and some of them haven't been directly applied to all public authorities, because there was a concern that we didn't want to create an unwieldy bureaucratic process of reporting and obligation. And so we can probably look at maybe going further in terms of directly applying these legal obligations to all public authorities, but certainly all of these apply to government, and some of them apply to public authorities as well. And so I think that was a really important part of it. In terms of measurement and evaluation, that's always a tricky one. We're still very much working on that as we move into some of these cycles. And it would be fair to say that we're not there yet. But there's lots of learning that we can do. And again, I see colleagues from Wales here, and Charles is here, and others in Wales who've actually done a lot of really good work on that under their children's rights measure, where there's been a lot of work on kind of measuring and evaluating that. But we've got a wee way to go here in Scotland.
Can I actually pick up on a question from our colleagues from one of our colleagues from Wales, and the question is, in Wales, many are arguing that we need to be more robust in making children's rights real. And as incorporation proceeds, are there lessons, best practice approaches being recorded or disseminated? And he wants to thank you, and you're so pleased that Scotland's been so bold. I just want to move to Scotland, so.
Well, I think one of the great things about these discussions is that I mean, we were really inspired by what was happening in Wales, and we worked really closely with Northern Ireland. I think the conversations that happen between Wales, Northern Ireland, and Scotland, less so unfortunately in England, are really powerful. I mean, some of the things around age of criminal responsibility and physical punishment, which are two other things that we managed to achieve in Scotland in recent years, getting children out of prisons, changes to the issues around how we deal with children in conflict with the law. These are things that we only achieve through discussion and learning from each other and being inspired from each other. And Scotland still has a long way to go if we look at child poverty and mental health and other issues. We're not there yet, but any success we've had has been done because we've had the collaboration of all of you. In terms of how you move this forward, we've got a publicly funded body, the Improvement Service, which is looking at this, and they're collecting really good information and promoting best practice. The Children's Commissioner is also doing some of this as well, and so there's work ongoing, and some fantastic academics as well. So there is work ongoing, but we've probably got a little bit to do in terms of making sure that it's properly structured. And again, I think we can learn from some of the evaluative kind of methodologies in Wales and other places.
Okay. There's a question here, and I'm not sure who it's from. But what are some of the most common arguments against incorporation that you've encountered, and how did you and others rebut those?
Yeah. And this probably speaks to something in terms of getting your allies on side. Some of the surprising detractors on this were some colleagues from our academic community who some really frustrating discussions for people who have devoted their whole life to children's rights, but who wanted to kind of make some of the academic arguments against incorporation in a really unhelpful and frustrating way. I've just written a book chapter on this, which will be published later in the year, but where some were saying, actually, the CRC is this 35-year-old document based on consensus at an international level. We need a domestic rights framework, and actually, so that was one of the big ones that came from some academics who were pro children's rights but anti the international framework, or didn't see the international framework as the most effective way of delivering on that. And so that was one of the things that was a real challenge. Then there were some of the links between some of the really challenging issues that we were discussing in Scotland, like the age of criminal responsibility, which we were discussing at the same time, or in relation to physical punishment as well, in terms of saying, will incorporation force us to make changes that should happen in the political sphere? And I thought this was a really interesting discussion as well, that there was some pushback from politicians in terms of saying, well, we live in a democracy, and actually these are things that we should be deciding, which is why it was amazing we got unanimous support from across our parliament to say, actually, this is a framework to help you make better decisions within the democratic process. This isn't forcing you to do anything. This is providing a framework for you to deliver on promises already made. And so I think that was really interesting, that some of those early discussions about saying that, hang on, this is imposing some international framework, we were able to deal with that very quickly by saying, actually, no, this is based on the UN system set up by we the peoples, where we were involved in the drafting of the convention, that this was unanimously agreed across the world and ratified by all but one country. We can be really confident that this is a framework that we can take ownership with and deliver really Scottish specific results under, and it actually improves our democracy. And I think that the fact that we won that argument is proved by the fact that we had not once but twice unanimous support across Parliament, including from members who, if you look at their voting records, would raise some pretty serious questions about their commitment to children's rights. But they all signed up twice to passing the UNCRC Act.
Yeah, I think this is definitely part of the conversation that we need to go deeper with you at some stage, because certainly some of those arguments are ones that we've had here. I'm conscious of time, so I've sort of a question that I would like to sort of hear your reflections on, and it's, what, if anything, would you do differently? And what advice would you give those in this jurisdiction who are on the journey of trying to secure incorporation? And you've only got 5 minutes. No challenge there, Bruce.
No. So what would I do differently? There are a few things where we got blindsided by going back to some of the academics who I think probably if I'd had a quiet coffee with and kind of got them on side earlier, then they wouldn't have made so much trouble with it. So there are a few people who I didn't engage with early enough in the process that I would have thought more about. The legal community is another one, and so that's why these conversations are really useful. Making sure that the legal, so I wouldn't make the same assumptions that all children's rights academics and all lawyers will see this as a good thing. So it was the kind of the outliers that then were raising quite legitimate discussions and challenges, but at an unhelpful time in the process. And so I challenged some of my assumptions that kind of everyone's on board. What else would I do differently? Probably not a huge amount, because I think that this was about taking the opportunity that was there. We had a government that had been very positive about talking about children's rights, but had been very slow to actually take action in relation to children's rights. And so we really pushed really hard. And so some of the negative elements of it, it was really challenging. The relationship with government was really difficult, but I don't think that I would have done it differently. I did receive a lot of criticism, including from civil society colleagues and from my own staff at the Children's Commission's office for the very possibly adversarial approach that I took to really push and challenge. But that was because that's what children and young people had demanded quite rightly from me as their commissioner, to be brave, to be savage, they told me, in holding government to account. So I don't think I would have done that differently. I suspect if you asked my former staff in civil society, they may say that taking a more consensual approach might have still delivered the same results in a more kind of celebratory way. But yeah, I probably can't comment too much further on that. But I think we really need to celebrate the leadership that children and young people showed through that. And so I'm not keen to give advice, but what I would say is what children and young people said consistently to us is that this has been too long coming. You have to work beside us, amplify our voice, be brave, stand tall, and yeah, make this happen. And so the advice that children and young people consistently gave to me was that this is so important to us. It's the most important law that will ensure our rights and change our lives. So you need to be really brave here, and you need to stand up and get this done. And so I really took that to heart, and it would be the piece of advice that I would pass on from children.
Bruce, thank you for being brave. Thank you for being Balchi. Thank you for pushing hard. Thank you for listening to children. Congratulations on what you've achieved. You've certainly are a shining light for us, and I think we've still an awful lot to learn from you in relation to how we secure incorporation here. I hope you'll be with us on that journey. And help us and hold our hands and sort of, tell us when we're getting it wrong or we think you're getting it wrong. I know you're over for a Nikki event on the 17th of June, and I think it's important that we continue this conversation and engage as many children and young people as early as possible. Academics and lawyers, I'm taking that away very much from today's discussion. But I can't thank you on behalf of everybody on this webinar. I think you've given us an awful lot to think about and to learn from, and onwards and upwards, as they say. Thank you.
Thank you. It's been my absolute pleasure. And again, I know there's some Nikki colleagues on the call, and I think that's been really exciting to see the real leadership that they're playing in relation to this issue as well, and all the civil society colleagues and academics on the call as well. If there's anything I can do to support your work, then I really look forward to that.
And thank you all for joining us today, and we'll be in touch in terms of future seminars as well. Thank you very much.